Hi, this is Brian Ka with another video to help you pass the California baby bar exam and the California bar exam. So we're gonna do another wills and trusts question, and this is from February of 2015, and this is question 6. So as usual, we're gonna go through the call of the question or questions and see what they want us to focus on. So it says here, Zoo has petitioned the court to modify the trust to provide for the care of its animals generally. And the first question says, is Zoo likely to be granted? And likely to be granted on what? To modify the trust. Provide for animals generally. Now, the only time that you're gonna deal with modifying the trust, usually, I haven't seen any other modifications of a trust, is when you have to deal with a charitable trust. And within charitable trust, there is a doctrine called Cyprus doctrine. Now, when you have to, or when you create a trust, let's just go over what it takes to create a trust. Um, Obviously, you're gonna need a settlor. You're gonna need an ascertainable beneficiary. You're gonna need trustee. You need a valid trust purpose, which is not illegal, so legal, right? And trust rests. Now, for charitable trusts, this ascertainable beneficiary changes to um, an entity, not, it can't be a person, right? It can also be for perpetual duration. So when a trust, a charitable trust, has ascertainable beneficiary, that means it's probably not a charitable trust. Um, Now, when you when it comes to Cyprus doctrine, this deals with number 4, which is a valid trust purpose, which has to be legal. Cyprus doctrine basically seeks to replace the purpose of the trust near as possible to settlor's intent. I think that knowing what a charitable trust is, right, it needs to confer benefit to the society, right? Another question that we had in the previous essay we did was that when you're trying to sue a charitable trust, a regular individuals do not have standing to sue And that question was asked earlier in the previous video again. And in that question, because only attorney generals can sue charitable trusts, that question which dealt with can be sued this charitable trust, the answer to that question in the previous essay was that because it was a charitable trust, only since only attorney generals can sue, they didn't have standing to sue. But it did talk about once that happens, once the attorney general initiates a lawsuit, then the plaintiff could get constructive trust as remedy. And that was what the previous question was about. So I think that we may deal with whether the zoo is a charitable trust. And if it is, then we're going to have to probably talk about the Cyprus doctrine and go through all these facts or elements to prove whether or not the valid trust purpose could be um, modified according to what the zoo has petitioned for, right? So I think that knowing all this is crucial to uh, answer the first question. The second call of the question was, what rights do Greg, Susie, and Zoo have in trust assets, right? So let's read the fact pattern and see what we can get out of it. So 2011, Tess, who was aged 85, executed a valid will, leaving all her property in trust for her grandchildren, Greg and Susie. Income from the trust was to be distributed to the grandchild or grandchildren then living each year. At the death of the last grandchild, any remaining assets were to go to Zoo for the care of his elephants. Okay. In 2012, the court appointed Greg as conservator for Tess because of Tess's failing mental abilities. In 2013, the court authorized Greg to make a new will for Tess. Greg made a new will for Tess, leaving Tess's entire estate to Susie and himself outright. Greg, without consulting Tess, then signed the will in the presence of two interested witnesses who also signed the will. So it seems like the third paragraph, when you get the word disinterested witnesses, that calls for an analysis of whether this will was valid, right? Because typically a valid will goes into two categories. One is attested will, and the other one is holographic will. And we went over this, I think, twice already in previous essays. For attested wills, you're going to have some elements that must be satisfied. The first is signed and in writing, right? And in writing. Now, the signing, the testator, when the testator is signing it, um, the the witnesses must be present, or the sign must be acknowledged in their presence. Thirdly, these witnesses must be disinterested, meaning they can't be beneficiaries and witnesses at the same time. And the witnesses must sign the will before um, the executor's death. Okay, so we have 4 elements that must be satisfied to make sure that the will is valid, right? And I see this being tested a lot. So knowing what is required for a valid attested will, I would say, is crucial to our success in doing well on the California bar exam. Just to remind our memory, holographic wills are handwritten, signed, but material terms must be handwritten, right? So I guess holographic wills are easy to memorize because there's only like 3 things, but tested wills are a little bit complicated just because you have, um, you know, I forgot here, 2 disinterested witnesses here. Um, it's a little bit complicated because you have to memorize what it takes to create a valid will. And I would assume that when you become an attorney, you're going to have to make sure that all these elements are satisfied when you have a client who wants to draft the will. And you're going to have to say, hey, make sure you have 2 disinterested witnesses, make sure that you sign it in their presence or acknowledge the signing in their presence, and so forth and so on. Okay, so here in 2014, Tess found a copy of the will drafted by Greg and became furious. She immediately called her lawyer, described her assets in detail, and instructed him to draft a will um, leaving her estate in trust to Susie alone and excluding Greg. Income from the trust was to be distributed to Susie each year. At Susie's death, any remaining assets were to go to zoo for the care of its elephants. The new will was properly executed and witnessed. Okay, so for attested wills, what we talked about here was will formalities, right? But when you talk about the will itself, you're going to need 3 things. And the first one, obviously, is the will formalities. The second is you need to have capacity and intent. Now, this is where it gets complicated because what we dealt with here was under formalities, but under capacity, we also have to have 18 and over, understand the nature of bounty, understand the nature of his assets, also understand the nature of actions. So the reason why I brought this up is because um, in the 4th paragraph, when they say that when she immediately called her lawyer, described their assets in detail, instructed him to draft a new will, leaving her estate in trust to Susie alone and excluding Greg, is kind of hinting that we're going to have to talk about whether he had capacity to draft a will, because here in 2012, the court appointed Gregg as conservator for Tess because of his of Tess's failing mental abilities. So obviously, this mental abilities needs to be argued from both sides, right? Here's plaintiff and here's defendant. So I think these are all the rules that we're going to have to know to work on this essay. So whether the zoo's petition likely to be granted, I will talk about briefly, if you want, what a valid will consists of. I mean, not a valid will, valid trust. And we talked about what a valid trust requires: settlor, ascertainable beneficiary, trustee, valid trust purpose, trust res. Usually, when I see fact patterns say that they drafted a valid will, I don't really go into uh, the requirements to create a valid will. But in this scenario, it seems like there's no trustee. Here it says he left his trust, or her trust, for her grandchildren, Greg and Susie. Income from the trust was to be distributed to the grandchild or grandchildren then living each year. At the death of the last grandchild, any remaining assets were to go to zoo for the care of its elephants, right? So settlor was Tess, so that passes. Ascertainable beneficiary, we have um, Greg and Susie, right? After the death, the remainder was the zoo. Okay, that passes. The trustee is the issue here. So I would talk about this, write this, and say courts will often not terminate the trust for not having trustees. It will appoint, right, a trustee if possible. So my point is that yes, I see that there's no trustee here, which is one of the requirements for a valid trust. However, courts often like to appoint a trustee if other elements are present. So in this case, although a trustee is not named, it is possible that the court will just appoint a trustee in this case, right? Now, we kind of have to talk about a charitable trust, because a charitable trust is a little bit different, since um, the benefit conferred is largely to the society, not individuals, right? Or ascertainable beneficiary. So in this case, um, the remainder was to go to the zoo for the care of its elephants, and that likely passes the charitable trust test. Um, Obviously, we have everything here except for the trustee part, in which we decided that this trustee will most likely be appointed by court, but there is valid trust purpose and there is trust res, the property that Tess had in her trust, that's the property or assets. Settlor was Tess. So only thing is, since this question is asking whether this valid trust purpose element could be replaced from a specific elephant to general um, animal care, we're going to have to go into the Cypress doctrine and talk about how Cypress doctrine seeks to um, put the intent of the trust as near as possible to the settlor's intent. And obviously, this is going to be argued from both sides because, um, from the zoo point of view, the argument is um, something like Tess didn't show any specific attachment to a specific elephant, which means that Tess's intent was probably more general than specific. Whereas um, the opposing counsel will probably argue that, you know, it's obvious from the trust language that the the settler wanted to take care of elephants only, and that deviating from uh, that those instructions would defeat the whole purpose of uh, of the original intent by the settler. Therefore, the zoo should not be able to petition and modify the trust. And then I will talk about, the court will most likely, um, you know, try to come near as possible um, to the intent of test, unless using extrinsic evidence. If unless the zoo shows extrinsic evidence showing that the test had specific, you know, attachments or some kind of a relationship showing that it was uh, only specific elephants that were supposed to be taken care of through this Cypress Charitable Trust. um, it will be most likely that taking care of general animals, is as near as possible to Tess's intent. Therefore, either uh, zoo's request to modify the trust under the Cypress doctrine will be granted, or if you strongly feel like this wasn't enough to come as near as possible to Tess's intent, then this Cypress doctrine under these facts, the charitable trust, their request for modification will probably fail. Now, I think the bar model answer said that yes, the Cypress doctrine and the zoo, since taking care of general um, animals comes as near as possible to the instructions or intent of the settler test, it will likely be granted. But I feel like it's, you know, it's taking care of elephants versus general, like cats, tigers, lions, and bears. So to me, it seems like, it shouldn't be granted, but I don't think the bar graders care about what conclusion you get as long as you talked about what a valid trust requires, that you understand what is a charitable trust, what as long as you understand the Cypress doctrine, as long as you plug in all the facts to show that whether the request to change it to a general um, animal charitable trust comes as near as possible to the settlor's intent, or on the other hand, it comes short from um, reaching the settlor's intent. I don't think that, again, conclusion really matters as long as you argue both sides, use all the facts given, and then say, um, you know, not granted or granted. I personally feel like it shouldn't be granted. So if this was like a real test situation, I would try to argue that there's no way that that replacing specific elephants to general animals, there's no way it comes as near as possible to the settler's instructions or his intent, her intent. Therefore, it shouldn't be granted or it will not be granted. But if you strongly feel like it should be granted under these facts and patterns, I think that you're free to do that again, as long as you argued everything here and then you flushed all the facts out and then you came to a conclusion. I think that's what matters to the bar graders. So moving on, what rights, if any, do Greg, Susie, and Zoo have? This is the second question that we're going to have to deal with. So here, this valid trust that we talked about was from 2011, right? Now, in 2012, the court appointed Greg as conservator for Tess because of Tess's failing mental abilities. Okay, in 2013, uh, we don't have space, so let's see. Um, where should we? There's like really no space today. Okay. So in 2013, the court authorized Greg to make a new will for Tess. Greg made a new will for Tess, leaving Tess's entire estate to Susie and himself outright. Greg, without consulting Tess, then signed the will in the presence of two disinterested witnesses who also signed the will. So here, you know, if we talked about the formalities, capacity, and intent, in the beginning of this essay, now we're going to have to talk about specifically formalities and go through these will formalities requirements and make sure that it follows everything here. Uh, in 2013, Greg, without consulting Tess, signed the will, right? Signed in the presence of two disinterested witnesses, right? So it satisfies a second element here. Here, the third element we wrote here was witnesses must be disinterested, so that passes. Signed by testator in the presence uh, of the witnesses, or the sign must be acknowledged, right? Now, here it says the fact pattern says Greg, without consulting Tess, signed the will in the presence, so it passes 1, 2, and 3, right? And whether or not the witnesses sign the document before Greg's death, let's see here. Greg, without consulting, then signed it in the presence of two witnesses. It says here the two disinterested witnesses who also signed the will. So the 2013 will formalities, obviously, I would quickly talk about capacity, intent, and then talk about formalities. And it seems like we have all the um, requirements to create a valid will. So 2013 valid will or a 2013 will was valid, right? So when you have a 2000 a valid will, a subsequent will that is valid, it replaces the previous will basically by revocation. So 2000 will is gone. 2011 will is gone because 2013 will is most likely, or it is valid. However, the facts here point to undue influence issue because here um, Greg made a new will for Tess, leaving Tess's entire estate to Susie and himself outright. And Greg, without consulting Tess, then signed the will in the presence of two disinterested witnesses who also signed the will. So we talked about undue influence in one of the questions previous videos. It was for another essay in another year. And I remember talking about prima facie, undue influence, there's case law, there's statutory, right? Prima facie, basically, there's vulnerability of defendant, you know, plaintiff took advantage of it, which results in unnatural result. Case law is when there is fiduciary relationship, you know, plaintiff took actions taking advantage of it, unnatural result. Statutory is when plaintiff was the beneficiary and the law doesn't allow it by statute. So here, I think it's easily proven, or we could prove that um, obviously Tess was suffering from mental illness, so there was vulnerability. And Greg, without telling Tess, um, without consulting Tess, signed the will and leaving entire estate to Susie and himself outright. So most likely, after we go through these three undue influence elements, three types of undue influence, we're going to probably find that there was undue influence, which invalidates the 2013 will. So this is invalidated. However, there's another 2014 will, right? And this is when Tess found a copy of the will drafted by Greg and became furious. She immediately called her lawyer, described her assets in detail. So here, as soon as you get the words, she was able to describe her assets in detail. I think that they want us to go through the capacity requirement of the will. Obviously, we're going to have to, establish here that there was intent and also formalities. But the main thing here is whether there was capacity, because unless you understand the nature of the bounty, nature of your assets, and nature of your actions, and if you're not able to understand, and if you're not of sound mind, then this defeats the capacity element that's required for a will. And um, unless you have all three things, formalities, capacity, and intent, a valid will is not established, right? So here, I would have to, argue both sides, saying, yes, she did understand the nature of her bounty. Um, she instructed her lawyer, to draft her estate in trust to Susie and excluding Greg, so she was aware of who was her bounty. Income from the trust was to be distributed to Susie each year, and even went as far as talking about how at Susie's death, income from the trust was to be assets were to go to zoo for the care of its elephants. So here, it's most likely that she understood the nature of her actions. She knew for sure the nature of her assets. Whether she understood the nature of her bounty is obvious here. And this obviously has a counter argument. And if you have time, since this is a really long essay, I would talk about the counter argument of uh, Greg, who will say that no, she did not understand the nature of her bounty. No, she did not understand the nature of her assets. No, she did not understand the nature of her actions. But, a reasonable jury will probably conclude that she did, in fact, have valid capacity, which means that um, even though 2013 will was invalidated because the subsequent will revokes the previous will and replaces it, then 2014 will becomes the valid will. And in answering what uh, Greg, Susie, and Zoo ends up getting, here the last will, it says here uh, that she wanted the she instructed the lawyer to draft a new will, leaving her estate and trust to Susie alone. So Susie gets the assets, right? Exclude Greg, right? And the remaining assets were to go to the zoo for its elephants. Now, I would answer or conclude the second call of the question by saying, yes, Susie is going to get the rest of her assets. The zoo, we concluded earlier that if the court decides that um, that uh, Zoo's petition to modify the trust into um, replacing the trust purpose from taking care of the elephants to general animals, if they approve it, then this will be good enough. But if they don't approve it, obviously it's going to go into intestate, right? Now, Greg has one final argument. He could probably argue that he's an omitted child, right? But omitted child is when the person drafting the will wasn't aware of the existence of the child, right? When the testamentary instrument was created. Now, obviously, um, you know, Tess knew about Greg's existence. So that's the first test that fails. The second is for omitted child. There are three exceptions. The first one is when the creator intentionally left out, right, the child from the will, unless there are two more. The second one is um, if they left something to the child, to the parents, or if they left something outside of the will, which neither of these apply. So she intentionally left him out, and she also was aware of Greg's existence, obviously. So this omitted child argument by Greg will eventually fail. So I think that should complete this question. Um, And honestly, this question was not that easy. You had to be really organized. I don't think you had time to like go over like, for example, like 2013. If you had to go through like each of these elements and argue both sides, you probably didn't have enough time to finish this essay. So I think the trick for this essay was to outline everything from the beginning to the end. And by the time you outline it, I would think that you are probably going to have like 30 minutes, 25 minutes. So obviously you're not going to be able to write like really detailed back and forth arguments, but you're going to have to, argue that for like 2013, formalities, capacity, intent, you're going to have to briefly say they're satisfied, but spend a little bit more time on capacity. Go maybe a sentence going back and forth, whether Tess said intent or whether Tess said uh, capacity, whether she understood the nature of her bounty, nature of her assets and actions. You're going to have to talk about that. Because this was a two-part test, the first section wasn't that bad. All we had to do was to talk about Cypress doctrine and will formalities for charitable trust. But the second part question was fairly complicated. So you had to really organize this. And if you didn't organize, most likely you would not have done well on this question. So the conclusion for today is that I think it is so vital to outline these questions before you work on them, because you have to kind of measure uh, as to how long you're going to have after you finish outlining everything, so that by the time like 45 minutes time rolls around, you have enough time to finish them. Otherwise, there's no way you can write a good essay within 1 hour. And yeah, I think that, again, this was a very difficult one for me. I've said this over and over again in previous videos that wills and trusts, I don't think I'm going to practice. I just don't like it. I don't like, I want to go argue and do litigation, but I obviously, again, this is something that we're going to have to master in order for us to pass the bar. So again, I hope that that was helpful. Again, know that you're not the only one struggling here with these questions. I am too. I'm sure other people are too. These are not easy, and if you find them hard, you're not the only one. Um, and because of that, I hope that watching me struggle, trying to get through it, and trying to remember everything was kind of messing with my mind. It was so much information that I had to know, but keep practicing. Me practicing on the whiteboard under pressured environment. Recording also helps me tremendously. So again, I want to thank you for watching this video, and I'll talk to you next time.